with so many high-profile cases happening recently, from the McMichael trial in Georgia over the murder of Ahmaud Arbery, to the trial of Kyle Rittenhouse, to the ongoing Elizabeth Holmes trial. We wanted to take a closer look at these cases and why there is such a big interest in them. Joining us now, Rachel Fiset. Rachel is a white-collar criminal defense lawyer and partner with Zeiback, Fiset, and Coleman. Also joining the conversation to kick off the show, Bryan Hance, attorney at law, professor and academic program director of the Pre-Law and Paralegal Studies program at National University. My thanks to you, both of you, for taking the time. Rachel, let's kick things off with you. Why are these high-profile cases taking place around the same time, if there's any link at all? And really, why is there so much public interest in them? This is making national headline news day after day inside what happens all these court trials.
Good morning. I think you have a confluence of events going on that is making them all very interesting to the public all at once. One is that there were some delays as it relates to COVID. So you couldn't gather a jury pool and that kind of thing for a while. So in general, the court systems are backlogged, and now a lot of trials are going forward. The other thing that is making it interesting to people is that amount of information that we can get through social media and the news every day. And it's feeding us, and we are able to stay apprised in so many more ways, you know, as social media and other news outlets expand. And then I think the third reason is that people are more interested in some of the issues that are in these trials, like the inherent race conflicts that are going on as it related to the Rittenhouse and the murder of Ahmaud Arbery and that trial, the McMichael trial. So I think you have a lot of issues kind of all on the rise at the same time, and they're all coming together so that the public is very aware and engaged in what's going on.
Bryan, let's bring you in here to the conversation. I'd like to get your perspective on this idea of potential bias among jurors. I remember there was one potential jury member in the Rittenhouse trial who was dismissed after making some kind of joke. I mean, obviously, we're talking about incredibly high-profile tragedies. Is it even possible in today's day and age, between social media and national news coverage, to have a completely unbiased jury pool?
I think it's a lot tougher, that's for sure. I mean, you know, the reality is we all have biases, whether we recognize them or not, regardless of social media and the news cycle. I think the question asked of jurors is, can you be fair and impartial in deciding a case? Can you keep an open mind to the best of your abilities? I mean, I tend to look at the glass half full. I think most jurors are able to do that, and those that can are weeded out in jury selection. But to Rachel's point, you know, there are a lot of high-profile cases right now. People want to see results, and with these cases, we're seeing a lot of race and social justice issues, particularly since the Derek Chauvin trial. And I think people are frustrated and they're angry and they're scared. And so they're bringing those emotions to the table. And I think they not only want to see what's happening in these cases, I think more importantly, they want to see what the results are. And I think the media is doing a good job of shining a spotlight on some of these issues.
Rachel, back over to you here. When you talk about the McMichael and Bryan trial down in Georgia, as well as the Kyle Rittenhouse trial, of course, that we had in Kenosha recently, you know, they are similar only insofar as this idea of a vigilante, you know, and that's kind of part of the defense. But fundamentally, these were vastly different cases. And of course, we did have vastly different outcomes. What does this say about this moment about so-called vigilantism? Obviously, we've got these sweeping nationwide protests and oftentimes tragedies that come about as a result.
I think the vigilantism is a result of some of these states' gun control laws and how the statutes are written such that you can claim self-defense as it relates to the actions that happen even when you are the only person that has a gun. So in each of these cases, the defendants were the only armed people, and the victims were unarmed. And that is a lot of what these cases have in common. And then both of them claimed that they felt their lives were in danger, even though they were the ones with the weapons that eventually shot the victims. So the gun control laws combined with these self-defense laws, and this is a state-by-state situation that goes on, are making for some really frankly bad defenses, maybe a bad verdict here and there for sure. And so this is what's going on, and it's in a way spurring on people to take on justice as they may see it, or law enforcement duties where they are completely untrained and it's not their job.
Of course, and at least in the case of the Rittenhouse trial in Kenosha, those claims of self-defense certainly hold it up in the minds of those jury members. Bryan, back over to you for a fascinating debate that I love down in Washington, D.C., where I usually work and live, this idea of increased transparency, even incrementally so, with regards to the Supreme Court. Now in the era of COVID, we do allow for sort of live audio feeds. At times it even results in more humorous moments. You hear maybe a justice flushing a bathroom or something in the background. But this idea of increasing transparency for the Supreme Court, the highest court in the land that holds, quite frankly, the future for the rights and privileges of so many Americans. How do you see that debate continuing to play itself out? Do you think we'll actually see cameras inside the Supreme Court in our lifetimes, or is the institution, quite frankly, a bit too old, a bit too archaic and set in its ways?
You know, that debate has been going on for decades, and especially on the federal side, the federal judiciary has been really reluctant to allow cameras in the courtroom for a number of reasons. I mean, you even had the Chief Justice of the U.S. Supreme Court that said having a camera in his courtroom may impact his behavior. Justices Alito and Kagan have said the same or similar things, and so, I mean, I don't foresee any changes anytime soon, particularly at the highest court. But there is this desire to have greater transparency. You know, people, again, they want to know what's going on, especially in these high-profile trials. And I think we also, it serves some purposes in terms of educating the public and promoting greater understanding of the court process. And modern technology has allowed cameras or other devices to be less intrusive. But there's some downsides to having cameras in the courtroom as well. And I think the court recognizes that, and I think they're going to be reluctant to allow cameras in the courtroom.
Rachel, finally, I would love your personal perspective on this. Increased transparency, is it a good thing overall to have a more informed citizenry more closely and intimately understand what happens inside courtrooms? And oftentimes, do you see perhaps the behavior of a defense or a team of prosecutors begin to behave a little bit differently if they think they're more publicly on the record?
I like the transparency, and I think in both the Arbery and Rittenhouse cases, we were able to see what's going on in the courtroom, and it was very eye-opening as it relates to the judge in the Rittenhouse case and some of the attorneys in the Arbery case, where the defense attorneys would say what I would consider somewhat racist, outrageous things, and then you would get more backlash because there was public involvement, and then they would have to temper that, apologize, that kind of thing. So I do enjoy the public's engagement. I think it's a good thing.
We didn't even get into the debate of sequestering potential juries. That's a different conversation for a different day, the one we will have. My special thanks to both of you here to kick off today's edition of Fast Forward. Rachel Fiset, white-collar criminal defense lawyer and partner with Zeiback, Fiset and Coleman. And Bryan Hance, attorney at law, professor and academic program director of the Pre-Law and Paralegal Studies program at National University. Thank you both.